that they're investigating. In Mazur, the issue of pushback was, well, what do these business records have to do with what you're looking at? These are not directly related to that matter. That was the litigable issue. That's different than here, as you know.
Right, but the issue still has to be litigated under the Presidential Records Act with respect to whether these records have any aspects of privilege that they're entitled to, and that has to be determined.
Privilege is a separate issue. I'm just saying, and just for the audience, if you look up the case, it's Mazur, and it actually reaffirmed Congress's oversight role in these matters. Now, in terms of privilege, I don't see this as a very deep well. We've never had a former president exercise privilege. It has been established in law that this is a privilege that goes with the office for the benefit of the Republic.
That's not right. That's
Really?
not right, Chris.
The
You
Supreme
keep
Court was
saying
wrong?
that. You need to read. You need to read GSA versus
I've read
Nixon, which unequivocally says that former presidents are entitled to claim the privilege. Now, whether it applies or not is a separate issue.
Exactly. See, but
They
that's
are entitled.
you're
They
being
are
clever.
entitled to claim it.
You're
No,
being
I'm not.
clever.
I'm reading the Supreme Court case.
But you're not reading it in context. Does a president have the privilege, a sitting president have the privilege of his executive immunity? Yes. In all cases, no, which is why the primary holding of Nixon versus GSA was seizing and examining records related to a former president that are still within the control of the executive branch does not violate the separation of powers. The privilege is not for the benefit, is not for the benefit of the president as an individual, but for the benefit of the Republic.
Correct.
Which means it has to make sense in context. He's not even a president. He's a former president. So when have you ever heard a former president assert the privilege successfully?
The privilege doesn't vanish because he's not in office any more than the attorney-client privilege vanishes when the client dies in the Vince Foster case or a member leaves Congress under the speech and debate clause. The issue is whether the functions of seeking confidential advice from advisors survives the president leaving office, and it does. Whether or not these particular documents in toto fall within the privilege is a separate issue. That's the issue that will get litigated in his lawsuit.
I understand the argument, but I don't see any basis of precedent for it because it's not like the attorney-client privilege. Because with that, the privilege goes with the client. Even if the client dies, it's always theirs. This goes with the office. So if you are no longer president, you don't have it. And the proof of that is, Counselor, the only time a former president has gotten the privileged protection is when a current president has offered it, which is why Trump's guys asked Biden. And Biden said no.
Well, that doesn't end the issue because there's still the question of whether any of these records convey a record of the confidential conversations about matters within the office of the president. And that has not been determined yet.
But it has been determined by the sitting president who has the right to assert the privilege, not a former president. You have literally no precedent that this has ever been established under law. I get your argument. You can make it, but that doesn't mean it's there. And also, you have a factual problem. You haven't had an assertion of this imagined privilege by the former president on behalf of your client.
Well, yes, you have.